So good morning and good afternoon, everyone. My name is Jeremy Wu, and I'll be moderating today's APA Justice Monthly meeting. This is the first time in 5 years that we open the meeting to broad participation and use the webinar feature. What you see on the screen right now would give you the agenda for today. We're very glad that we have Professor Margaret Lewis to talk, to lead off the talk for today. And the agenda, as I scroll through the screen, would start with the brief introduction that has a link to Professor Lewis's bio at Seton Law School. And we anticipate that we have invited Crystal, I should say, from KPAC to speak. But at Congress, she is pretty busy, so we don't know for sure. And if we can see a confirmation that she's on, we'll invite her to speak for 5 minutes. Otherwise, we'll start with Professor Lewis. And I would like to mention that we want to thank UCA for allowing us to use their Zoom service. I also want to thank Stephen Pei and Vincent Wang for all their work behind the scene. Professor Lewis will follow with a 40-minute presentation on the Department of Justice China Initiative, which will include a Q&A session. We have already received a set of questions. We also encourage you to submit your questions through the Q&A feature at the bottom of the screen. We'll try our best to bring them into the Q&A session. 2020, Andre Sack recipient Professor Xiaoxing Xi of Temple University will lead off the Q&A session. John Yang, AAAJ, will help to wrap up the Q&A session with a last question before providing an update on AAJC's anti-racial profiling project and the latest on the justice and policing bills in Congress. Greg Orton will then share with us the civil rights aspect of the 2020 policy platform from NCAPA. My role as facilitator is to keep the call on schedule, facilitate the Q&A sessions after each presentation, and transition from speaker to speaker and from item to item. I may be rude and apologize in advance if I have to interrupt because time is running out. We're scheduled to end the call at approximately 1 o'clock Eastern Time. Today's meeting is recorded. A written call summary will be produced and posted at APAjustice.org, as we have in the past few months. We'll try to address any remaining questions in the call summary if feasible. There is a LinkedIn account and a Facebook account where you can join. And in fact, much of the activities of APA Justice happen in between monthly calls. Today we have Professor Maggie Lewis as a new speaker. Other speakers are returning, and we thank them all for sharing their time. So let me pause at this moment, and ask the speakers whether there are any questions or comments before we start. If not, Crystal, are you on? Yeah, please, would you start off, Crystal?
Sure. Thank you so much, Jeremy, for having me on today. Just wanted to give a few quick updates on behalf of KPAC, the Congressional Asian Pacific American Caucus. So in February of this year, we sent a letter along with the House Oversight Committee with Chairman Raskin, who chairs a subcommittee on civil rights, to both the NIH and FBI requesting information specifically on practices related to what we believe has led to increased profiling of Chinese American scientists. And so we received a response from NIH on April 15th, and then we received a response from the FBI on May 13th of this year. And then actually last month, the NIH had a staff briefing for us on June 10th, along with the House Oversight Committee, and then I was there on behalf of KPAC, just at the staff level. I'm not allowed to disclose, because this is an ongoing investigation with House Oversight involved, I'm not allowed to disclose a lot of the information, but as of now, we are, in terms of next steps, we are trying to get a classified briefing with with the FBI specifically to discuss our letter in more depth. And just so you know, I can't go, like I said, into their response too much, but it isn't anything new in terms of the fact that, largely what they responded to us is that they don't racially profile, and there aren't, both NIH and FBI claimed that the cases that they have prosecuted are legitimate. And so, and one of the things I will disclose with NIH, they kind of gave us three main reasons that, they are finding reasons to prosecute folks. And it's either one, because of undisclosed research support, two, undisclosed conflict of interest, or three, due to peer review violations. And so those are the three major buckets that they are finding violations where they've been able to then prosecute folks. And then they have said that about 80% of the cases that they've identified are people who identify as Asian. So they said they don't actually disaggregate the ethnic breakdown, but again, the fact that, an overwhelming majority are Asian. Many of them, they did say, have ties to China, due in part to the fact that the Chinese government tends to recruit expats. So, those from China who are now working in the United States. So that's kind of what they gave us. It wasn't anything, like I said, it wasn't that helpful in terms of answering a lot of our questions, which is why we are really pushing for a classified briefing at some point. Of course, with the coronavirus, that has made it a lot more difficult. We were actually in conversations with the FBI prior to March to try to get a classified briefing set up. And now that's become a little more challenging because we would have to figure out a way to do that safely, in person, in a secure location, where, both those from the FBI and also our members of Congress would be able to maintain social distancing. So we are, figuring out next steps, but are trying to get something scheduled because we really don't believe we're going to get more answers until we are actually able to do this in a classified setting, because everything we've received in writing so far, and even through some of the briefings we've received as well, have not been extremely enlightening in terms of answering our questions and really getting to the heart of what we're trying to investigate. Also, I know on June 23rd, some of you may know, the White House Office of Science and Technology Policy also released its guidelines on enhancing the security and integrity of America's research enterprise. And so that's something we're combing through as well, because I know we had been asking, and not just us, I know a number of institutions have been asking for just broader guidance from the federal government. So, that has finally been released. We're still kind of combing through that, but also wanted to flag that is something. And then lastly, I wanted to flag that last year in the Intelligence Authorization Act, Congressman Ed Case was able to successfully include an amendment that requires the intelligence community to submit a report to Congress. And so that was actually supposed to be submitted by June, but because of the coronavirus, they are actually have been delayed a little bit. So I think we're expecting that report to come to us hopefully by the fall. And that is supposed to analyze, whether our current policies or the impact of our current policies rather towards China, what they may have on the civil rights of Chinese Americans. So we're eagerly awaiting that report. I know for this year, the Intel Committee is also working to try to get similar language that would make this an annual report to Congress. So we're still in the process in the House of working on our bill, but that is something that we're trying to get in there as well. So those are the major updates on my end.
Thank you so much, Crystal. At this point, let me turn to Professor Maggie Lewis. She has written a very insightful paper about the DOJ's China initiative, and it's titled Criminalizing China. The paper is scheduled for publication in December. It provides a pretty concise analysis and observations about issues of great concern about justice and fairness to the Asian American community. And with Crystal's lead in, Maggie, may I turn the floor to you? And the title of your talk today is China virus is not acceptable. If China virus is not acceptable, why is China initiative acceptable? And how the US government's use of criminal prosecutions to address a broad China threat deviates from the foundational principles of the American justice system, and what should be done. So we'll have a Q&A session after this. The floor is yours, Maggie.
Thank you, Jeremy. Thanks for inviting me. And I will definitely speak for less than 20 minutes, so we have time for Q&A. And I need to apologize that I will have to hop off after my part of this session, because I need to brief congressional staffers on Taiwan and what's happening in Hong Kong, which, as you all know, is increasingly disturbing by the day. And I want to begin, though, by giving a little background on how I come to these issues, brief introduction to the China Initiative, though I expect everyone on this call is quite familiar with it, and then really focus on thoughts about strategy and where to from here. So I come at this topic as someone who studies criminal justice, both in the United States and in China. So I was an East Asian Studies major, first studied abroad in Beijing in 1995. I have no Asian heritage. And so I think that's important, because part of one thing that I want to emphasize is the need for allyship, that these concerns should not just be on the shoulders of the Asian American community, that this affects all Americans, and that's important to build ties outside of those communities. And I also want to recognize that I can't fully understand what it's like right now to be Asian American, particularly Chinese American, in the United States, when we've seen for several years now increasing anti-China sentiment, and certainly since COVID-19, that the weathering that occurs, that day-to-day othering, and that's how that wears on people. And so I realize that I don't understand fully that lived experience, but I do want to reach out as an ally in any way that I can. And I also want to just emphasize that I tend to be pretty academic, pretty pragmatic. I have friends who are prosecutors. I try to see where they're coming from, because I mean, this is a time where, in my work with China policy more generally, I've certainly never seen the US-China relationship at a worse point. And this is going to continue. There's going to be tension. And so we need to recognize that there are real concerns about what the PRC party state is doing. And this is not only part of government policy, but part of the more general zeitgeist. And that we need to be realistic about what that means for options. So going back to how I came initially at this topic, and I realized that APA Justice was founded in 2015. And in 2015, I had published an article in a law review titled "When Foreign is Criminal." And in that article, I was just starting to come to realize how much under the Obama administration already there was increasing focus on economic espionage, which has only been a federal crime since the mid-1990s. And so economic espionage is taking trade secret theft and elevating it to a serious federal crime based on that the intended beneficiary of that intellectual property is a foreign government or something, an entity connected to a foreign government. And you saw in the Obama administration, the FBI started putting out more threat awareness briefings, threat awareness films like The Company Man, Game of Pawns, and these more overt warning about particularly China, but also more generally foreign threats. So then we go forward to the fall of 2018, when then Attorney General Jeff Sessions stood up and announced that the Department of Justice was forming a China initiative. So again, this wasn't completely new, but it was new in the sense of saying, First of all, that DOJ was naming an initiative after a country, which is, from best I can tell, unprecedented. It was unusual, to say the least. And also making very clear that DOJ was going to put a lot of resources, a lot of time behind this initiative, that this was a priority. And we've only seen that the China initiative has gained momentum under Attorney General Barr. He's spoken very favorably of it. Certainly FBI Director Wray has been out there a lot at conferences and in the media. And it was only in late June that he was on Fox News. And he had previously, like in February, been saying that the FBI had 1,000 active investigations sort of under the umbrella of the China initiative. But he upped it to saying there's 2,000 in his conversation with a Fox reporter. And I've actually just this morning was tweeting with Mara Histendal and others, because I think it's important to recognize that when this number gets thrown out there, what it tells us is that a lot of government resources are being put behind the China initiative. The increase in 1,000 to 2,000 tells us nothing about whether there's an increasing prevalence of criminal activity. And we also don't have a breakdown of these 2,000 cases. How many are more sort of economic espionage, the thieves and hackers? Think about Tappy the robot's arm being stolen from the T-Mobile lab, versus how many of these are these, peer review violations or something of a very different nature, but maybe somehow have a connection to China. And I think that, so it's great to hear from Crystal that there's trying to get some more, at least general breakdown of what these numbers mean, because I get very concerned when a 2,000 number is being thrown out there, and that feeds into this narrative of China as an existential threat without giving us the tools to understand really what is the nature of the concern, and giving us some granular data. So that's, a little bit about where the China Initiative started. And then personally, in November of 2019, the U.S. Attorney's Office for New Jersey, which has a great relationship with Seton Hall, had asked to come and give one of these threat awareness briefings, particularly to the life sciences companies that are based in New Jersey. And in the process of doing that at Seton Hall, they got me on the panel. I have not been invited back, but I'm still hopeful. And so that was really my introduction to the PowerPoint presentations they were using, the rhetoric they were using of, again, this whole society threat, the existential threat, the Communist Party of China being emphasized. And that made me increasingly concerned about who was driving the bus of the China Initiative and how it was being carried out. And so I wrote the paper, which is in draft form. It's up on SSRN. Got some typos I need to work out. I blame that on pandemic parenting. But when I went into this paper, which is a 30,000 word monster because it's a law review article, I really set out to say, well, what are the standards that the Department of Justice sets for itself in going about its work? And is the China Initiative living up to those standards? And I don't think it is. And first I talk about why the China Initiative is too expansive. Because it's not just about the PRC party state. And I'm trying to be more intentional of not just saying Chinese government, but PRC party state, because, as anyone who studies China knows, that the real node of power is in the CCP. And although when we talk about Xi Jinping and you see him and his name in the Western media, they say President Xi because that's the more familiar title. When you're in China, they never refer to him as President Xi. It's General Secretary Xi because that's his real power. So I think we need to get more understanding of the nature of the PRC party state and be more precise in our language. And so, and I was happy to see, for example, and the link I think is in the material sent out today, the Committee of 100 encouraging campaigns to be more thoughtful about the language they are using when they talk about China. So, but when I hear what DOJ is saying, a lot of times they're talking about communist China. And so that puts this sort of threat narrative out there and harkens back to times in our history that I certainly don't want to revisit. So yes, the PRC party state is responsible for all sorts of awful things. You know, you look at Xinjiang, they're behind IP theft. I spent my career criticizing the human rights record, but I think the Department of Justice is not being precise in how they're discussing the node of the threat. Because when the China initiative is discussed, it also brings in, as people on this call know better than I do, it brings in people whose DNA connects them somehow to the PRC, nationality or national origin, even if they've changed their citizenship. And also more generally, what I discuss as people who have China-ness. And by that, I mean, you'll have press releases for prosecutions under the China initiative that will be for, you know, Caucasian, you know, white, no connection to China ethnicity. However, the press release will say, and he speaks fluent Chinese, as if my ability to speak Chinese puts me in a position of being something to be concerned about, as compared with an asset for the United States of being able to communicate people with people in another country. And even going back, you know, much farther than the China initiative, you look at like the Wenho Lee case, and yes, he was, you know, ethnically Chinese, but he was Taiwanese, and not just that, he was a Benshengren. His family had been in Taiwan during the Japanese, you know, colonial period. And so, you know, it just shows how it's a very broad idea that goes much further than people who are actually connected to initiatives that are under, you know, the sort of the PRC party state's control. So I think we need a lot more precision in the language. And then second, I say, well, okay, why do we prosecute? What are the principles of prosecution? It's because the Department of Justice has decided that this person should be punished. And we punish because of deterrence, incapacitation, rehabilitation, and retribution. And under those standards, I also think the China initiative fails. So for example, over deterrence, that you have this using of the blunt instrument of the criminal law to try to stop bad behavior, but in the meantime, it has a chilling effect and sometimes straight up incapacitation through visa denials, through disallowing cooperation between certain entities, like certain universities in China, and that we're cutting off some benefits to the United States. Because the research shows, and Macro Polo and other organizations have done analysis of data of intelligence and human capital flows, that so for example, with artificial intelligence, the United States economy benefits from the flow of people coming to the United States who understand that work. So I think that there's a lot of reasons to think that there's going to be hurting the United States by having these barriers put in place. I also worry that China is being anthropomorphized, and you hear this talk about China's malign behavior or we have to deter China. Well, China is not an entity that can be subject to the criminal law. It can't itself engage in malign behavior, but it creates this sort of boogeyman. And so with all this, I really do worry about how this whole initiative is being framed and now carried out. So what do we do about it? So I'm going to give you 5 suggestions in my last sort of 8 minutes, and these are non-exhaustive. So I first think the DOJ should just remove the China initiative name and adopt a country-neutral framework. Now, and that's important for non-discrimination reasons, and for being clear that the US should seek to protect certain interests from threats wherever they emanate from. And I realize this is a necessary but insufficient step. You could still have this, same thing going on, but just without the name, the China initiative. However, I think that a name change is a first step that on itself might look cosmetic. It opens up the conversation to say, we need to do a better job of figuring out what are these interests, what are the concerns that we're going to protect with the criminal law. And then we're not just going to say, and we're protecting those interests from China, but rather we're protecting those interests wherever they might be threatened. And part of this, I look at what's going on now and hearing things like, the peer review violations. I mean, generally I would not think that peer review violations would be something we would use the federal criminal law and federal criminal prosecutions. I mean, that's a really severe step. So how do we draw lines to say we want to keep the fundamental research open? And you can look back at like the 2019 Jason report that talks about that there's a lack of common understanding on key issues of even when we're in the realm of open science collaboration, that we really want to make sure that people can communicate openly. And then when do we cross the line into protectable IP that we should protect using the civil law, that an individual or a company could bring a civil suit? And then when do we move even further and say, this is a national security concern that we want prosecutors to be able to bring federal criminal charges that can deprive people of their liberty for substantial periods of time. And right now, I'm not a scientist, so I can't draw those lines, but my sense is that there isn't the kind of conversation that needs to be going on between the scientific community and the DOJ to have some clearer and better line drawing. So second, I think we need to curtail the further criminalization of academic misconduct. And by this, I mean that we need to strengthen the non-criminal law alternatives to address the concerns at which the China initiative is aimed. Now, the Department of Justice itself in its Justice Manual says that a reason not to commence prosecution is that there exists an adequate non-criminal alternative to prosecution. So we need to make sure that we have those non-criminal alternatives. We need to streamline, think about better auditing, better grant oversight, better education about what are the requirements when you have these grants so that we don't have to use the criminal law. Because when you use criminal law, it's kind of like if someone has cancer and you use old school broad chemo or radiation that might kill some bad cancer cells, but it also kills a lot of good cells in the body. And that's what the Department of Justice China initiative seems to me is doing. How can we have more targeted therapy that's going to just get the bad cancer cells while leaving intact the positive aspects that we want to keep going? And so for this too, I think there's actually some, might get some traction in Congress. So I looked, and for example, even on the Republican side, there's concerns about over-criminalization more generally. So Chip Roy from Texas has introduced the Count Crimes to Cut Act, and that would require an accounting of all federal crimes to enhance clarity, transparency, and fairness. So I think when I hear that there's efforts to maybe introduce even more federal criminal laws aimed at grant fraud or sort of peer review violations, that we need to be more judicious and cautious about even adding more sort of crimes that can be used by the Department of Justice. Third, I think we need to expand beyond a negative agenda to a positive agenda. And what I mean by that is, yes, there are threats from the PRC party state. I don't want to be naive and Pollyanna-ish, but at the same time, so much that I see right now from the US is how to protect the US from these threats, to create barriers, to stop research, to stop visas, as opposed to thinking more about sort of the Sputnik moment and how do we have a positive agenda that puts the US in a more competitive space. Because I think we can all agree that the US needs to compete hard with China, and we need to be wary of the PRC party state. But one of the best ways to do that is to better ourselves, is to invest more in our own research and to make it so we have even better IP. Because the reality is that when you're protecting today's intellectual property, that's not enough. You need to continuously be creating new intellectual property that's even more advanced, more valuable. So you need the research environment that supports that. And we need Congress and also the executive branch to support what needs to be done to keep the US in that competitive space. I also think we need to do more to get country expertise, linguistic expertise. My sense looking at the China initiative, it's very much being driven by the counterintelligence people within the Department of Justice. And they're gonna look at this from the lens of counterintelligence, and that's their job. And so we need to make sure that there's also people who have country expertise and other aspects that will give a more well-rounded view. So fourth, I do think we need to push back on the prosecutions that are underway and in the pipeline while being realistic about how far a data-driven approach can take us. We're not going to get fantastic numbers. You're already seeing this out of DOJ. Prosecutors' work is notoriously opaque, even when you don't have a national security concern. So there's always going to be asymmetric information. Yes, keep pushing for that information, but just be realistic about how much is going to come out there. Like, what does this 2,000 number mean? A breakdown would be great, but I don't think it's going to happen. Usually we don't hear details until there's an actual indictment that's been issued, which is very late in the game. And with selective prosecution, those are extremely difficult cases to win on. One of the cases that's still taught in just general case books is the case of Yik Wo from the 1800s. And here we had someone who was a subject of the emperor in China who was denied a permit in San Francisco. And that just goes to show how hard it is to win on a selective prosecution claim. I think those cases are important to bring attention to these issues, but they're not going to be how essentially the Department of Justice changes its behavior. I think it'll ultimately be because there's a change in leadership at the DOJ, and or that the Department of Justice sees that they can protect US interests in a way that is less rooted in the heavy-handed use of criminal prosecutions. Finally, I do also think that there is a need for greater diversity, equity, and inclusion initiatives in the Department of Justice and society, of course, more generally. Again, I don't think this is going to solve the problem, but it is an important step. I don't think the Department of Justice officials are going to take an implicit association test and then realize that we are all biased human beings. But you look back, and we're talking with Jeremy and Vincent and others about how under Sally Yates and the Obama administration, there was an initial step to start rolling out more implicit bias training. My sense is that stopped under Trump. And the problem there is that, I'm sure you've heard this too, and just my last thought before I go to Q&A is that the officials, when they talk about the China initiative, they tend to have at least one sentence that is along the lines, but we love the Chinese people and we welcome the Chinese people, and this is not being racist. And that's not good enough. That is not an antidote to all the other framing, all the other language being put out there. And in fact, it can serve as a micro-invalidation. And so my comparison as a woman is, if someone says something sexist to me, and then they say, but I'm not sexist, that doesn't mean what they just said wasn't sexist. It just means that they're not recognizing how what they're doing is being heard by me and experienced by me. And so like history warns that we should be very cautious about letting concerns about national security overwhelm other values. And so that's a lot in a short time, but I do want to have time for Q&A. So I'm going to stop there and throw it open to questions.
Thank you, Maggie. That's a tremendous presentation. I'm asked to turn on the video, and I'm still trying to learn how to do that. But in the meantime, let me introduce quickly Professor Xiaoxing Qi. He is a scientist. He's not a lawyer. He's also the recipient of the 2020 Andrei Sakharov Prize. And he's a victim of racial profiling. And his case was brought up and dropped in 2015. And that was one reason why APA Justice was created in the first place. So with that, Xiaoxing, you're from Philadelphia. You're the professor of Temple University. Would you lead off the Q&A session for us, please? Thank you.
Sure, thank you, Jeremy. And thank you so much, Professor Lewis, for your wonderful, comprehensive, very clear and insightful comments on the China initiative. I am actually very much struck by your reference to the DOJ Justice Manual, which says the ground for declining prosecution is there exists an adequate non-criminal alternative to prosecution, right? According to DOJ, actually most China initiative prosecutions of university professors are for failure to disclose China ties, not for stealing secret. And you mentioned the Jason report that was commissioned by the National Science Foundation. The Jason report recommended failures to disclose China ties should be investigated and adjudicated by the funding agencies and by universities as presumptive violations of research integrity, with consequences similar to those currently in place for scientific misconduct. So there is evidently an adequate non-criminal alternative to prosecution, right? So from, I'm an academic, and from an academic perspective, prosecuting failure to disclose is clearly over-deterrent. In particular, for the actions that occurred when the guidelines for disclosure were not clear or non-existent, and China collaborations were encouraged. And it harms the United States by discouraging international scientific collaborations on fundamental research, which stifles American innovations. And according to this National Security Decision Directive 189, fundamental research is open and unrestricted, which is an important reason for the American competitiveness in science and technology. And another reason for the American competitiveness is the talents around the world that America attracts. And the over-deterrence has already sent many talents back to China. You know, my question is, does China initiative make the prosecutors more reluctant to drop cases, even when they are wrong? We see the case of Emory professor Xiaojiang Li, who was charged for not disclosing China ties. You know, Li said he had disclosed, and eventually he pled guilty to for failing to report China income in his tax returns, which was about 35,000 tax underpayment over a 7 years period. And we see the case of University of Kansas Professor Franklin Tao. You know, he was charged for having signed a university talent program contract, but not disclosing it. You know, Tao said that he never signed any contract. And then the superseding indictment then charged him for not disclosing his selection for the talent program. And then a few days ago, there was a second superseding indictment, which further said he entered into the contract, even though he signed no contract, because he still collaborated with the Chinese university. So my question is, do the prosecutors have to get a win, no matter what, because of the China initiative?
No, thanks for those comments and question, and I know that, you know, this is, you know, something which is, you know, so terribly affected your life and the life of many other scientists. And so I begin by saying that prosecutors their job is to do justice, and they are told, they should be taught that it is not to secure convictions, because that's not supposed to be the goal of their work. And you know, however, when a lot of resources are invested in investigation, I think part of it is that you get blinders on, and then they start getting, you know, this narrative of what the case is, and it makes it sometimes harder by human nature to then drop cases. And, you know, we've seen that again and again outside of the China Initiative context. Just watch the documentary on the Central Park Five, when you had 5 African-American teenagers who were wrongly accused and spent years in prison, in part because they said that the police and prosecutors were convinced they got the right people, and they couldn't see past that narrative that they had established. And I also say I worry a lot about the messaging that's coming from the higher ups in the China Initiative. So for example, Demers, who is the Assistant Attorney General for National Security, has said openly to the media, and he's quoted in a Politico article, saying, well, you know, you're not going to see tons of these cases because they require a lot of resources, but essentially he says he hopes to see that all 94 federal districts have a case, and maybe not this year, but then next year. And so that's not a strict quota system, but it's very clearly saying, hey, look for these cases, and if you don't find one, then we're kind of wondering what you're doing. And so I don't know, is there a case in North Dakota, or are those prosecutors in the District of North Dakota saying we got to find a China Initiative case? So that kind of messaging, of course, can influence the behavior of people who are operating within that system. And then you look at statements also made by U.S. Attorney Lelling in Massachusetts, where he has said very openly, yes, the China Initiative will have a chilling effect, and that's a good thing. So there seems to also be, my reading of that, at least some people involved in the China Initiative have said, well, we want to have essentially over-deterrence, that we think we need to have this heavy hammer of the criminal law. And I think that goes against the ethos that is in the Justice Manual, that the Department of Justice, the rules they have long set for themselves. And non-discrimination is also in the Justice Manual. So even if it might not be a case that can be won under constitutional standards, which is a high bar, what the China Initiative, the language around it, I think goes against the ethos, against the principles of non-discrimination that the DOJ has set for itself. And just finally, I also want to just emphasize this moment we're in U.S.-China relations, where engagement has become a fraught word. I have to be careful when I use engagement because it somehow makes me an apologist. That any connectivity with China is seen as being putting people in a place of being, why are you communicating with China? Which is not only bad because it cuts off scientific research, but I think it's also bad because then we don't know what's going on in China. And so to build walls and decouple makes it so we don't understand the other side. And so it is not just about scientific research, it's also more generally putting the US in a worse position if we don't engage and understand not just China, but the rest of the world outside our borders.
Thank you, Maggie. I'm going to lump a few questions that have been raised for today's session here into one. In general, there's the question of what recommendations do you have for nonprofits to help fight the China Initiative? Is this a fight mainly within Congress and the courts? And then the related questions would be, how do you build allyship outside of the Chinese American group? And there's also agreement with you about the need to form coordination between the scientific community and the community organizations. How do we proceed? Can you talk more about how the China Initiative will influence the Chinese Americans? What can the Chinese American community do to deal with the practice? So let me lump all that together and see how what do you think about that?
Right, and of course this is all more difficult when there's a pandemic, and we can't have these same sort of roundtables and all this in-person communication that we're all missing so greatly. So I think there's a couple different levels to this. So from the legal side, I understand that, for example, like the ACLU is already involved, but I think there's other organizations that I don't know if they've been contacted, or so the Brennan Center or the Vera Institute for Justice or Marshall Project, or all these organizations that have worked more generally on issues, whether it be bail reform or about racial profiling with stop and frisks. The CCR, the Center for Constitutional Rights, which was instrumental in the Floyd case in New York, which talked to the NYPD about their stop and frisk practices. And so these are organizations that tend to have not only lawyers, but also the social scientists who can do the regression analyses and try to figure out what's going on here. And I think that there's, so that's one avenue, which potentially there's more work that could be done. And I can tell you there's a lot of law students right now who have time to do these kind of projects because their traditional internships aren't happening. So I think this is also ripe for clinics at law schools who might want to do more advocacy work. And I think that's another avenue because there's a lot of great talent out there in the law schools, and this is exactly the kind of work that they would want to be involved with. Another kind of sort of NGO or civil society aspect, which I think should be explored, is also looking at what's going on with better briefings of the people involved in the China Initiative. And I've said this before, and it seems so kind of silly, but understanding how to pronounce Chinese names. I am consistently appalled at the lack of understanding even how, pinyin romanization, and I do a lot of work with Taiwan, and I'll admit the Taiwan romanization is a little bit more complex because you don't know sometimes what you're dealing with, but just even, basic understanding of, I said, like the PRC party state, And I think for that, organizations like the National Committee on U.S.-China Relations, which I do a lot of work with, they're now making a push to look at more closely discrimination against Asian Americans. They've had some recent programming about that. And they have a long history, going back to ping-pong diplomacy, of working with congressional delegations, of working with the government. So I think perhaps an organization like that, that's more middle of the road, it's not seen as an advocacy organization, might be an avenue to start having some more communication with the government because they might be better positioned. So I think it's both about making it so that we have people who could push the government more through the advocacy side, but then also find the organizations that might be seen as essentially less threatening to the government as nodes to increase and build bridges. So it's not just the FBI showing up to give its threat initiative or try to get information, but really have a two-way conversation.
Thank you, Maggie. Here's another question that deals with accountability. What recommendations would you give regarding how to hold the government accountable for any case that eventually ends in dropped charges, dismissal, or a not guilty finding? What is the best policy instrument to remedy the victims?
Yeah, and so first of all, it's a good thing oftentimes when the government drops charges, and I don't want to penalize the government for dropping charges, because the nature of investigations, if they're done correctly, is as the investigation goes on, you get more information. And so it could be that a prosecutor is doing an excellent job of initially saying, this looks like there could be criminal activity, investigating it further, then realizing by talking to potential witnesses or looking at the data that actually there isn't a case there. Then I want the prosecutor to feel that they can drop that case without being, without having negative repercussions. So I think we have to be really careful about penalizing for not guilty verdicts or for dropping cases. I think it's more about, this is where I think it's really important to have the bias training and everything to say, why are you looking at these people in the first place? What is it about this person that made them seem like a suspect, whether you realized it in the front of your mind or you just were automatically drawn because of something going on in the back of your mind that this person is somehow suspicious. And this is seen here, but certainly you talk to people that, Black and brown people get targeted more, and there's a lot of reasons for that, and I think there's some parallels here. I'd also say that plea bargaining is a huge problem in our criminal justice system in general, that it makes it so these decisions are opaque. We don't know what went into that plea bargain. That's often why too I think you're seeing these charges of tax fraud, obstruction of justice, other lesser, sort of charges that are easy to prove, because in the plea bargaining process, that's pretty easy for the prosecutor to say, we have your income, we have your tax statement, we've got you, plead guilty now or go to trial and you'll face a much higher potential penalty. So one thing too is I think that I hope that more of these cases go to trial, and I looks like Professor Lieber might be pushing towards trials, a few others, because when we have a case go to trial, you get a lot more information out in the public. The discovery rules make it so the prosecutors have to hand over a lot more. At the plea bargaining stage, federal rules are very restrictive about what prosecutors need to make available to the defense, let alone the public. So I think the other thing is just we have to have this less in the plea-based system, which applies to the government more generally, and get some more transparency by challenging the government's cases in courts. But that does increase the risk for the defendants that if they are found guilty, it will probably be a much more severe punishment than if they had pled guilty earlier on.
Thank you, Maggie. That's extremely valuable, I believe. We're hitting a point where we may have to close the Q&A session. And I would like to ask John Yang to raise the last question so that we can transition him into the discussion of the anti-racial profiling project. Okay, here's the original question. What recommendations do you have for how nonprofits can help fight the China initiative? Is this a fight mainly within Congress and the courts?
Right. So if you want me to answer that question from my perspective, is that, yeah. I think there's right. I mean, I think there's a couple of things. I think Maggie hit upon a couple of the organizations like ACLU, Brennan Center. Certainly some of these mainstream organizations are looking at this issue. already, ACLU in particular. We at Advancing Justice AAJC has taken a deep dive into it as well, especially with respect to the policy angle as well as the legal angle. With respect to the legal side, number one is working with groups like the ACLU. We actually are filing what's called a friend of the court brief in the Kansas case right now, a case called Tao, regarding similar issues. But then more generally, sort of we've embarked on this, what we call an anti-racial profiling project, focusing on Chinese American scientists and academics. And so this project, briefly for the people that are on this call, I think several of you have probably heard about this already. There's three components to it. One is a know your rights component, to educate our community about what your rights are if the university comes knocking on your door, or obviously if the FBI or law enforcement come knocking on your door. Number two is a legal referral network. We at AAJC will not be able to handle individual cases. That's just beyond the scope of what we can do, especially in the criminal context. But what we can do, and what we're setting up the network to do, is provide legal referrals to make sure that people are in a position that they can get the legal help that they need, whether it is criminal or civil, right? And we also recognize that for many academics and academics and scientists, cost will be a concern. And so that's how we're trying to structure this program, so that it's a program that the referrals would be to attorneys that could work with individuals as far as what the fee structure looks like. And number three is with respect to advocacy. And advocacy is with respect to Congress in terms of legislation, FBI and DOJ in terms of what these initiatives look like. I think what Professor Lewis said about a number of these things was spot on, right? Is on one level, career attorneys in the U.S. Attorney's Office try to do the right thing. Their obligation is to do justice. But then there's also the U.S. Attorney himself or herself is a political appointment. And anytime you have something called the China Initiative that comes from Attorney General Barr, or before that Attorney General Sessions, that will unfortunately have an implication on how career attorneys feel pressured to take on certain cases, and what types of resolutions that they come to these cases. And I think that's where we all need to do a deeper dive. When I say we, it's this network of organizations that we're talking about. In terms of what else everyone can do, right, one is, I agree, like with respect to the organizations, we all have different roles to play. So I've been talking to Z at C100, which I assume many of you on this call know, and figuring out sort of what our respective roles are, because we are an advocacy organization. So we are a civil rights organization. So we are going to come at it from a particular bent with respect to domestic civil rights. But then there are organizations like C100 or the Asia Society that can take a more foreign policy viewpoint to it, take a more economic viewpoint to it, because it's that whole notion of all of and different roles that people can play that will help affect that narrative, help move the needle on some of that advocacy. And then for regular community members is, certainly I would be happy if you guys reach out to me with respect to, we've been working very closely with Jeremy to sort of identify what all these cases are, common attributes to them, and how we want to put it all together to drive that narrative, right? Because the other aspect of this is that there's not that much research. I mean, obviously there's Andy Kim's study from a few years back. There's the 2019 research that Professor Lewis said, but we need more in terms of what these cases are, how they're being resolved. And there's a tension to all of that, because on one level, sort of, I agree that sort of we want to keep everyone accountable. And then there's that tension of what happens when charges are dropped. On one level, we should be happy that charges are dropped. But, is that a systemic problem with respect to why they were brought in the first place? And so we need more data, if you will, on all of that, so that we can make both that compelling case in Congress, in DOJ, in FBI, et cetera, as well as to start to change that narrative. Last thing I would say, because I know we're short on time, is with respect, I saw one question about, will this change, if there's a different president? Honest answer is it's unclear. A different administration can take a better and more nuanced approach. This administration clearly is using whether you want to call it a jackhammer, whether you call it a chainsaw, when, again, we think that a scalpel would be the better approach. Whether a new administration does that remains to be seen. And I think, again, that's a place that we as a general public can play as well. If you are involved in either of the political campaigns, you could seek to influence those political campaigns and how they approach it. The Biden campaign early on had a ad on China that was roundly criticized by the Asian American community for being racist and being no better than some of the stuff that the Trump administration has put out. I think the Biden campaign has learned from that. We'll see what happens from there. But that's another place that certainly everyone can have an influence on, is lifting up these issues so that political campaigns talk more smartly about this. It's not about China, it's about the CCP, right? It's about the Central Chinese Communist Party. I mean, that's bottom line what it is, right? And I agree, let's not be Pollyannish. There are definitely major problems, certainly for my organization from a human rights perspective, about the Communist Party. But that's very different than talking about China as a whole. So let me end there. I'm certainly happy to answer questions, but again, I want to be cognizant of time.
Sorry, and I'm going to have to jump off because I have to get on my other Zoom meeting, but I just want to say thanks again. I'm happy we've got a whole nother conversation about the campaigns. I agree. I think, Biden, no one wins a campaign being soft on China, and certainly not in 2020. But I have some hope in who's advising Biden on China. And certainly I think if Biden wins, the most important thing is going to be who's in that DOJ leadership, and who are in these top political posts, because that's going to set the tone. But we'll leave that for another day. Thank you, Jeremy. Thank you, everyone. And I'll hopefully be in touch on some of these issues going forward.
Thank you, Maggie. At this point, let me refer to Greg. You have heard the perspectives from Crystal, from Maggie, from John, and CAPA has a 2020 policy platform, and it's very comprehensive. You put it out every 4 years, and perhaps you can elaborate a little bit on the civil rights portion of the policy platform and share it with us.
Sure, thanks, Jeremy, and good afternoon, everybody. Hope everybody's doing all right. So a quick update on the platform we did recently release it, and as Jeremy mentioned, it is a comprehensive document that reflects the work of all 37 members of CAPA that covers all the different policy issue areas that impact the AAPI community. And thanks to AAJC and our civil rights co-chair, we basically included a section on racial profiling and discrimination as it relates to Chinese American scientists, as well as South Asian Americans, as it relates to lingering 9/11 fears. And so really the best way to think about the platform is that it's a top-line document that is designed to lay the foundation for our future work, depending on what happens in this November. If there's a new administration, as we've been talking about, the hope is that there'll be an opportunity to engage in a more meaningful and constructive way. And the platform is, again, designed to sort of lay out sort of where the community stands on a number of these issues. And I'm happy to report that we've had multiple conversations with the Biden campaign about the document, and so they are aware of it. And so because we have a section pertaining to Chinese American scientists, hopefully we can leverage that in the future. And so I'd welcome feedback from all of you, not necessarily on this call, but perhaps moving forward on ways we can sort of flesh that out further, add more details. I'll put a link in the chat box for the platform itself. It's rather long, but as I said, we're happy to sort of work with everyone to make it as robust as possible. And one of the benefits of being sort of sheltered in place and currently working in a virtual space is we can constantly update the document. In the past, we would have had to go into press and it would be much harder to make updates. But now that we can, like I said, happy to work with anyone to sort of make it as strong as possible and make sure that we're doing our best to put it in front of decision makers come next year. So happy to either answer any quick questions there, but also happy to give time back since we're short on time.
Thank you very much, Greg. Would you perhaps respond to the question as to what do you do with the platform when you say you meet with the policymakers? Does that cover also the upcoming national conventions for the political parties, all the way through to the new members coming in for the new Congress? And even for existing members, they may not be aware of some of the issues that are contemporary.
That's exactly right. And this document is intended for the public at large. It's also intended for current decision makers. So we've reached out to members of KPAC and other key members of Congress to talk about the platform, and we're setting those meetings up. It's also intended for candidates on both sides. Truly, if we want our voices to be heard, we need both, Democrats, Republicans, independents, whomever, to be aware of the issues that really and truly impact the API community. And so because we're a C3, we have to be careful as to how we approach the work, but as it's a public-facing document, anybody's free to take it, run with it, and basically put it in front of people. And so if you all feel compelled or find it useful to use parts of it, we're certainly open to that, and feel free to use the link to do that. And so moving forward, whether it's with a new Congress or a new administration, we'll refer back to the platform and continue to push them to sort of recognize these as important issues that they need to sort of integrate into their work plans for a new Congress or for a new administration. So I do think that, it's a good idea to sort of put it in front of new members of Congress, but the hope is that they also have an opportunity to look at it while they're candidates. And to your final point about the DNC and RNC, we've reached out to both to essentially have a similar meeting where we get to walk their staff through. As many of you are aware, the DNC at least is going through their drafting process of their own policy platform. And so we've had multiple conversations with their staff as well to try to encourage them to integrate sort of aspects of our platform into theirs. Senator Tammy Duckworth is on the drafting committee, and I've had a few conversations with her as well. And so our hope is that there are enough eyes currently on NCAPA's platform, and eventually we'll see parts of it included in the platform at the end product of the DNC's platform, maybe even the RNC, but we'll see.
Thank you, Greg. An hour comes and goes very quickly, so we're at the end of the session. I know that there are a few questions that we have not addressed, so what we'll try to do is to answer them, or at least gather the information to provide the answers for them in the call summary. And again, a lot of work will be done in between monthly calls. And as I wrap up today's meeting, the 3 reminders. As of this morning, the response rate to the 2020 census is about 62%. So we still have some ways to go. So please complete and return your census form today if you have not already done so. And in the agenda, you'll see that AAUC, OCA will have several virtual events in the month of July. And we do use the social media quite actively in terms of informing you, so we don't have to wait on a monthly basis about some of the ongoing events, and they have been quite active recently. And finally, our next August meeting is set for August 3rd. It is always the first Monday of every month, same time. So with that, I'm a little bit past 1 o'clock, but I do hope that you stay safe and healthy. And I want to thank all the speakers and all the people in the audience for your participation, for your questions, and we will try to address all of them as much as we can in the call summary. And in between, we'll try to connect and address the additional issues. So thank you all very much. Have a great day. Bye-bye.